Good morning. I am Jennifer Brooks. I am a staff attorney at the State Office of Information Practices, and I'm going to give you a quick introduction to our office and the laws that we administer. So we administer both the state's Open Records Law, the Uniform Information Practices Act, and the state's Open Meetings Law, the Sunshine Law. And for both of those laws, we give advice. We do take complaints, take appeals in, and do opinions on disputes. We do training. This includes a lot of training that we have online. And, I should note this isn't a training. We don't have enough time to do a training. This is really a very brief introduction, but we do have our guide to the Sunshine Law and guide to the UIPA included in the packet that you got. And we have full trainings that are online, including streaming, voice-over PowerPoint slideshows that you can watch if you want to get a full training on either or both of those laws. And then we also, during the legislative session, we do a lot of commenting on bills and so on that are related to our laws. We also assist in the state's Open Data Initiative. And we have what we call our Attorney of the Day service. Every workday we have one of our staff attorneys assigned as that day's Attorney of the Day, so that when you drop by, call in, send us an email, we have somebody who's available to answer general questions. And that's usually, usually if you call, usually somebody can take it right then, but if not, you'll get an answer within the day. So I will briefly touch on the UIPA, and then I'll spend a little more time talking about some of the basic elements of the Sunshine Law. But, again, as I say, this is an introduction rather than a training. So the Uniform Information Practices Act applies to government records, and so you should just be aware as board members that the records of your board's work are generally going to be government records, and as board members, there can be sort of fine points as far as things that are written from your personal email account. Is that really accessible to the government agency and so forth? But just be aware that particularly the records that are maintained by the agency that are relating to your board's work, these are government records, and as such, it is possible for members of the public to request them. Now, if you get a request for records in, it's probably not going to be coming to you as board members. It's probably going to be going to agency staff, the administrative staff that supports your agency. But when a record request comes in, a written request, the agency has to respond to within 10 business days. So that's 2 weeks typically, usually by doing a notice telling the requester what we're giving, what we're not giving, whether we're withholding it, whether there will be fees. Another thing for you to realize under this law is that records are presumed public. The presumption is that it's public. There are exceptions that may apply, but it's up to the agency to say why the requester should not get the record, rather than being up to the requester to explain why they should get the record. So, like I said, a very brief introduction to the UIPA, just so that you know it exists and that people can request records related to your work. I'm going to spend most of my time doing a quick run through of the Sunshine Law, some of the basic concepts under the Sunshine Law, since that's the one that's going to be more applicable to what you folks do as board members. So the Sunshine Law is Part 1 of Chapter 92 in the Hawaii Revised Statutes. It's the Open Meetings Law. It applies to meetings of government boards being a defined term under the Sunshine Law. For you folks, you can just assume that you are board members. And it applies when board members are talking about board business. So that would be anytime you're talking about specific issues that either are pending before your board or are reasonably likely to come before your board in the foreseeable future. So something on an upcoming agenda, something that isn't on an agenda yet, but is likely to be coming your way. Whenever you're talking to another board member about that, that's a discussion of board business, and so one way or another, the Sunshine Law applies. So to start with some of the concepts that arise before a board meeting, a board needs to file a notice and agenda before holding a meeting, and there's also a concept called board packet that's fairly new in the law, which I'll also touch on briefly. So the notice and agenda, that has a deadline for being filed. It has to be filed 6 days ahead. That's calendar days, not working days. 6 days ahead of the meeting on the state or county calendar, also with a copy to the lieutenant governor, or, well, in your case, you're all state boards, so state calendar, copy to the lieutenant governor, and keep proof of filing, and it goes out to people on the mailing list. Now that notice, in addition to time, date, and place, has to include an agenda that lists all the items that your board will be considering, with a limited ability to add minor stuff at the meeting by a supermajority vote. So the level of detail that the agenda has to have it has to be sufficient to inform the public well enough so that people in the public can consider whether they want to attend the meeting and testify on the items you're going to be considering, for which reason that you can't do things like having just old business, new business without further detail, because of course nobody knows what you're going to be talking about. You can't have catch-alls, things like applications, if any, because again, it's not enough for people to know if they're interested and they want to come and testify. And this is something where we have quick reviews and agenda guidance online if you want more information on the level of detail that would be required for specific items. But as board members, just be aware that, first of all, something that's not covered on your agenda, you can't start talking about at the meeting, and you can't allow for that. You can't get around that by saying, well, we'll just have a catch-all of, other applications, if any, or something like that. And then the other thing is to realize that even if it's your staff that's preparing the agenda, they need to be knowing a week or more ahead of the meeting what is going to be considered so that they can get that agenda prepared and meet the filing requirement at least 6 calendar days ahead. The other thing that comes up before a meeting is this board packet requirement. And this is something that applies only if you actually have a board packet. A board packet would be material that is pulled together and sent out to board members in advance of a meeting for their consideration before a meeting. So if you don't have anything like that, then actually there's no requirement to have a board packet. But if you do have something like that, and I think in many cases, many of your boards will have something like that, that might be pulling together copies of applications that you're reviewing or similar things. The requirement is that as soon as it goes out to the board, there has to be a public version of it available in the board's office with a notice sent out to the mailing list stating that it's available as well. Now, that doesn't mean if what you're reviewing includes confidential material, it doesn't mean that, well, too bad, it's all public, because the way the law is written, it does allow for withholding not only things that would not be public under the records law, the Uniform Information Practices Act, but also allows for, because of the quick turnaround, because this has to go out to the public at the same time as the board, it also allows for situations where if it's just too time-consuming to redact, you can withhold the whole thing. But generally, your staff is going to be wanting to, as things come in, they're going to be needing to prepare a public version so that that can go out at the same time that it goes out to you folks. So when you get if you're getting a board packet, when you get your board packet, be aware that there's going to be a public version of that people may be seeing, and if you get questions from constituents, you can point them that way. And also be aware that, if it should happen that you have something that you're suggesting, there's this federal government report that's relevant to the work that we do, and can that get sent out to the other board members? That probably can, but it will be part of the board packet, and so it will be subject to the same requirement. And for staff, by the way, well, I know PVL staff has already been trained on this, but just note that you're not required to automatically mail out this whole packet. The requirement is to have it available and accommodate requests to send it out electronically as soon as practicable. So let's move on to the during the meeting stage, some concepts that are important during a meeting. First of all, testimony. The public has the right to testify on any agenda item, and agenda items means there's not a right under the Sunshine Law to have a general public comment period. Some boards like to do that. Depending on the mission of the board, it may be appropriate for them to have a general public comment session, but just be aware that that's something that while you can choose to do that as a board, you're not required to. The requirement is to accept public testimony on items that are actually on your agenda. Now, testimony doesn't include a right to question the board, which again, is something you can answer questions if you want to, but you're not required to. I know some people, when they come in to testify, like to do it in questioning terms. How can you explain da-da-da-da-da? Why did the board da-da-da-da-da? Again, you're not required to answer questions as part of receiving public testimony. Testimony can be oral, it can be written, it can be both. Written testimony, typically an agenda is going to give people some information on where they can submit written testimony. If somebody submits testimony to you as a board member directly, just pass it on to the administrative staff so that they can ensure that it gets appropriately copied and distributed to other members. People can testify anonymously, more challenging in person, but either way, that means that while you can have a sign-in sheet and request that people sign in, you can't actually require people to sign in as a condition of testifying at a meeting. And people can testify on the same agenda, or the same agenda item each time it turns up on an agenda. Sometimes you have these issues where it's just meeting after meeting, it's on there for every meeting for 6 months running or something like that. And sometimes you'll get people who come and they give the exact same testimony every time, which you're just going to listen to it again because, again, the way the law is written, every person can testify on every agenda item at every meeting. Now, as a board, you can only discuss or act on items that are on the agenda, and while you have, as I mentioned earlier, an ability to add minor items by 2/3 vote of all members to which the board is entitled, which, by the way, means you have to have pretty good attendance if you're going to even do this, for the most part, just don't expect to be discussing things that are not on the agenda already, which means that if you get off-topic public comments, either in the course of their testimony on an agenda item, or if you have a general public comment section and they're talking about something not on the agenda, be aware that you can't, just because somebody raises it in testimony doesn't mean you can then discuss it. So you're going to have to typically have the chair say something like, "Thank you for your comments. It's not on our agenda at this time, but we'll consider it for a future agenda," or, that's going to be on our agenda for our meeting next month, or something like that. Now, the other thing that comes up during the course of a meeting is executive sessions. That's the Sunshine Law term for a closed meeting or closed portion of the meeting. If you anticipate having an executive session, like there's something where you expect you're going to need to talk to your deputy AG during the meeting with legal questions, or there's something where if you were in the position of discussing personnel, hire, fire, discipline, evaluation, discipline dismissal of personnel where an individual's privacy would be concerned, that's another one where you might anticipate you're going to be going into executive session. If it's foreseeable, put on the agenda, when you list the agenda item that you'll be discussing, also note that you anticipate going into executive session. If it wasn't foreseeable, if it came up and you realize at the meeting, say, oh, we have a legal question, we need to ask our attorney, you can still go into executive session. So it's not an absolute requirement that it be on the agenda, but if it's foreseeable, it should be. What you need to do at the meeting is to announce the purpose of the executive session. There's a limited list of 8 purposes, so you can't just say, we need to go into executive session. You have to say why, and the why has to be one of those 8 listed purposes in the Sunshine Law. And again, we have that Attorney of the Day service, so if there are questions ahead of time where you think you might need to go into executive session, but you're not sure you're able to, you can always call the Attorney of the Day. But, let's say you have a legit purpose, so you announce the purpose, you vote by 2/3 majority of those present to go into executive session, and then once you're in executive session, it's not a license to talk about whatever you didn't want to talk about openly. You're limited to discussing those topics that are actually on your agenda, of course, and that can't be discussed openly without frustrating the purpose for which you went into the executive session. So let's move on to concepts that come up after the meeting, and this is primarily the minutes. A board's minutes have to be online within 40 days of the meeting. The board has the choice to keep its minutes in either written format or recorded format with a written summary. And for those of you who've been sitting on boards for a while, you may be thinking, recorded format? What's that? That's relatively new, but it is something that was added to the law a couple years ago and now is an option. So written minutes are the way they always have been. Written minutes include the time, date, and place. They include who's there, who's absent, the vote for or against any motions by member. And by the way, unanimous votes work because the minutes already show who's there. So if the vote was unanimous, then you already know by member everybody who was there voted in favor. So you don't have to specifically list each name if it was unanimous, but if it was, say, a 5-to-1 vote by member does need to be reflected, so you would list names. The minutes need to reflect the substance of all matters discussed and the views of the participants, which means that written minutes should reflect who spoke and the gist of what was said. It doesn't have to be verbatim, but if a particular member spoke, you should be able to tell from the minutes that that member spoke and at least the gist of what they said, the general direction of their remarks. So you don't want to have in minutes things like discussion was had. Minutes are also required to include anything a member requests be included, and we interpret that to be anything a member requests at the meeting be included, because otherwise it doesn't work with the deadline to get them online and the requirement of accuracy in minutes if members can then have an absolute right to request additions or changes much later. So as a member, if you want something included in the minutes, you can insist on that, but do so at the meeting. Please let the minutes reflect that, something like that. For recorded format minutes, they need to include the recording itself, digital recording or analog recording, but as a practical matter, the board is generally going to want to take a digital recording because the minutes have to go online, as mentioned earlier. So the recording, a written summary. The written summary has to include time, date, and place, who's present and absent, vote for or against any motion by member. So far, this is all stuff that's also in the regular written minutes. The difference is that where the written minutes have to have the substance of all members discussed and views of the participants, i.e. either that transcript or the paraphrase of what all the discussion was. The written summary accompanying recorded format minutes only needs to have a timestamp or similar reference for when the board began discussion of every agenda item and of every motion or vote. So kind of a table of contents for people, whether it's board members, staff, or members of the public trying to see what happened at a meeting. They can, because recordings can be long and it can be very tedious to try and forward through to see when discussion starts. So this lets people know, agenda item 10A discussion began at 11:37, something like that. Now, written or recorded, all minutes have to be a true reflection of what happened. In other words, the law does actually require that they be accurate. Executive sessions, you're required to keep minutes. The minutes are not automatically public. You're not required to post your executive session minutes 40 days after the meeting like you are with the regular session minutes. But again, you do have to have them, and if someone requests the executive session minutes, the standard is that you can withhold insofar as disclosure would frustrate the purpose of the executive session. So immediately after the meeting, if you were properly in executive session and someone requests the minutes, for the most part, you're not going to be disclosing. Some years later, it's possible it would no longer frustrate the purpose. One of the executive session purposes is where a board is considering purchase of public land, for instance, and if it's 5 years later and the purchase has either happened or hasn't, it's likely you're not giving away much by revealing that. Others, though, like the personal privacy one, that might keep it indefinitely. So again, executive session minutes, be aware that you do have to keep, as a board, executive session minutes, but also be aware that they're not automatically public. Okay, final element I'm going to touch on is things that happen outside of a meeting, and by this I mean the permitted interactions. The Sunshine Law, I mentioned all the way up front that anytime you have board members discussing board business, the Sunshine Law is concerned. The Sunshine Law applies. If it's in a meeting, then obviously it's, all those standards we've talked about previously. If it is outside a meeting, then to be legal, it needs to fall within one of the permitted interactions listed in the Sunshine Law. So there is a special section in the Sunshine Law, this is 92.2.5 for anyone who's wondering, that sets out circumstances in which board members can talk about board business outside a meeting, and it is specifically permitted by the law. So I'll mention, first of all, the investigative groups or permitted interaction groups, or PIGs as they're sometimes called, because that's a frequently used one. This is the one that allows a board to name members, less than a quorum, specific members named at a meeting, and set their authority at a meeting, and then allows those named members who are now part of this permitted interaction group to go out, and they can freely amongst themselves or with other people who are not members of the board, they can freely discuss the topic assigned to them outside of a meeting without having to go through the whole open it to the public, keep minutes, and so forth. So when you set up one of these, sometimes they get used in situations where it's not that the board is trying to do anything secretly. Maybe it's something where they actually want to go out and talk to members of the community, but it's, for practical reasons, awkward to do it as a Sunshine Law meeting. But it can also cover situations where it's something that the board does want to do without trying to involve the community, either because it's something that's like, writing a response to something that came in from a federal agency, or writing a response to some other correspondence where it's kind of awkward to draft anything during an open meeting or a meeting generally. But it can also be things where, yeah, you are actively trying to do something where you're handling sensitive information that maybe doesn't fall under one of the executive session purposes, and so you want to have this less than a quorum, this small group of board members deal with it and then report back in a more sanitized way. Again, there can be various things that you're trying to do with it, but regardless, you have it so that the members of this small group now can discuss it outside of a meeting, but they can't involve the other board members who are not part of this permitted interaction group. They have to make sure not to cross the streams. Now, the permitted interaction group members report back to the full board at a subsequent meeting, and the expectation is that, they've been, the first meeting, the group was created, they go off, they do their thing, they come back, they report to the full board, and now basically they've dissolved. They're not continuing to meet. The full board then has to wait until the next meeting after that to discuss and take action on whatever the topic was. Our understanding of the reason the statute is set up this way is because otherwise the public wouldn't have any chance to weigh in before the board considered and possibly took action on it. This way the public gets to hear the permitted interaction group's report and can then testify on it at that next meeting before the board considers and takes action. So again, that's one that's frequently used. Other permitted interactions, well, there's the one that allows two board members to talk about board business to each other so long as they don't make or seek a commitment to vote. With this one especially, although it's true for all of them, be aware that you can't use it serially. You can't have A talk to B and then B talks to C, because now you have A, B, and C all privy to the conversation, even if they were never in the same room at the same time. Another frequently used one is there's one that allows less than a quorum of board members to attend an informational meeting as long as it wasn't set up specifically for the board and as long as, again, they don't make or seek a commitment to vote. So this means that there's a relevant legislative hearing, let's say, and you have a 9-member board, and there's 4 of you that show up to testify on this same bill. Well, you're okay because you're covered by this permitted interaction. However, you do need to report your attendance at the next board meeting. So that would be something like, I went to the legislative hearing on SB 1234, and members A, B, and C were also there. There was a lot of public concern about this bill, on this issue and that issue. It was very educational. It was something like that. Not a written report, in other words, nothing very formal. You're just letting the people who attend the meeting know that, hey, there were several of us board members at this event, and this is briefly what happened. Less than a quorum of board members can discuss leadership. The full board can discuss minor administrative matters with the department head. The full board can discuss anything with the governor, but it does actually have to be the governor, not the governor's chief of staff. And there's a couple of others that are not as often used. Again, OIP's role with this law is we offer advice both through our attorney of the day advice and sometimes advisory opinions. We take complaints and issue determinations on complaints, and we do training. And we are always happy to hear from you. If you have questions, you can call the AOD. I don't think we have a break now, so I can't take questions right now, but if you have questions later, you are welcome to either email me directly in this case or not forever. Don't email me forever. But if you have questions today, you can contact me or just contact our office and ask for the attorney of the day. Thank you.